Mom and dad are getting older and someone is going to need help take care of them. But who? Maybe you have 3 kids and working 50 hours a week as it is and just literally don't have the time. Or maybe you don't have tens of thousands of dollars each month to pay to hire help either. And your siblings, one lives in California, the other in Texas. I'm Tim Takis. I'm an elder care law attorney at Memento Law who helps people protect their assets so they can pass their estate to their family and not the nursing home. Look, nobody wants to think about their parents getting old and becoming incapacitated, but it's a part of life and it's something we all have to face. And when they do, costs tend to rise, and that's when the fighting begins. But all of this can be planned and avoided altogether. And that's what I want to show you. The reason this is important is that when your parents do need assistance later on in life, that's going to cost money, and that money is going to need to come from somewhere. And because the cost of care is so expensive, whether they are going into a nursing home or getting aides to help them in their house, what really happens is many end up exhausting all of their life savings on their end-of-life care. They spent 30 to 50 years building a legacy to leave to their children, the real estate they own, their investments, but unfortunately that's completely wiped out because those assets are used to pay nursing homes or hospitals. The way you avoid having this happen is by planning ahead of time, and that's where elder law comes in. What most people don't know is that by restructuring their assets, they could qualify for Medicaid or veterans benefits that would pay for the care they need without going broke. Instead of their assets going to the nursing home, they are able to leave a financial legacy for their children. What's important to know is that the government has a playbook of rules for what you can and can't do in order to qualify for these benefits. Once you know what you can and can't do, the next thing you need to know is how those rules apply to you. And then what you need to know is when it is time to pull the trigger on your plan. I recently represented a married couple. The husband had just been diagnosed with Alzheimer's disease. Because we were proactive in their planning and created a durable power of attorney several years ago, when he became incapacitated as his illness progressed, we were able to modify his estate plan. Working with his attorney, in fact, we created and funded a trust on his behalf that allowed him to qualify for veterans benefits and to provide for his spouse's support during his illness and upon his death. If we did not do this, the burden of all of the cost of long-term care would have been on their children or taken from their savings, leaving the spouse impoverished. Thankfully, we were able to create a plan that worked for the client and his spouse that met their legacy goals for their children. We understand that nobody wants to think about mom and dad getting older, dying, becoming incapacitated, or moving into a nursing home, but it's a reality of life. And as for everything else in life, you are better off when you are prepared. If you or someone you know who is approaching their elder years in life and want to protect assets so you can pass them down to family and loved ones, schedule a free consultation and we can explore all of your options. We'll spend 60 minutes exploring your entire situation and then come up with a specific plan of action that will keep your assets protected the way you and your family have always planned.